Good morning, everyone. I think all set for a webinar to start. Am I still audible? Can anyone hear me?
Yes, I can.
Yes, we can hear you, Richmond.
All right, thank you very much. So we can start. Good morning, everyone, and welcome to today's webinar. This webinar is put together by the law firm of Jackson, Etti Edu. And in this webinar, we have a seasoned jurist and a panel of experts who will be discussing the new trends in the world of work. The world of work, as we know today, has evolved rapidly in the last couple of years, particularly within the last 3 years due to the impact of the COVID-19 pandemic and also various technological disruptions that are known. This has created a number of changes in the work forms, the way we once knew the labor and employment relations. And the labor market keeps adjusting to these new forms of work with so much flexibility and mobility in the workforce. And this has had a lot of impact in labor economics, both within in the micro and macroeconomic scale. Many businesses today are seeking for ways to sustain job creation while at the same time coping with the shocks in the labor market. With these changes, there are opportunities to find new paths of remaining a going concern, as well as adapting to new ways of creating work and ensuring that work continues. These shifts in the world of work could also change in the near future. And that brings us to a reflection of what the future of work will be in the nearest future. And in this webinar, we'll be discussing the current trends, as well as how workplaces are adjusting to these new trends. We'll talk about hybrid work, remote work, what are the measures that will be put in place in ensuring productivity, accountability, what are the risks, the liabilities, remote work injuries particularly, and how are employers ensuring employee retention and business continuity, what are the immigration and tax issues, amongst others. To do justice to this topic, we have cerebral jurist, the Honorable Justice Ukwanya. We have a panel of experts who are masters in their own fields, Mrs. KBD Atime. We have Mr. Taiwo Adesina and Mrs. Rabi Adetoro. Before we move straight to the presentation, please allow me to quickly read the profile of our panel. Justice Ugbanya is a judge of the National Industrial Court. His lordship obtained his LLB from the University of Nigeria and was called to the Nigerian Bar in 1998. He also obtained his master's in law and postgraduate diploma in education, both from the University of Lagos. A fellow of the Chartered Institute of Arbitrator, fellow of the Chartered Institute of Taxation of Nigeria, and was appointed in the Notary Public of Nigeria in 2013. Until his elevation, in July 2017, his lordship engaged in combined legal practice as well as academics. He was a senior lecturer in the Nigerian Law School and head of the Department of Corporate Law Practice. He also authored the book, Essentials of Corporate Law Practice in Nigeria, which is an approved test by the Council of Legal Education. While at the bar, his lordship was an active member of the Nigeria Bar Association, Lagos branch. He had several positions and was also very active in the Human Rights Committee. He was co-opted into the NBA, National Executive Committee, and was a member of the NBA Constitutional Committee and produced the Constitution of 2015, served in various other capacities. In the course of his lordship's career, he was the pioneer presiding judge of the Yola division of the court and has also served in other divisions across the country. Currently, is the presiding and admin judge of the Warri Judicial Division, National Industrial Court. My Lord, welcome to the webinar. Thank you for honoring our invitation.
Thank you.
Okay, so our next speaker is Mrs. Ebi Ateme. Ebi is currently the head of Legal and Company Secretary of the Shell Petroleum Development Company of Nigeria Limited and all other share companies in Nigeria. She has over 30 years post-call experience as a legal practitioner, spanning across private practice, banking and finance, oil and gas industry. KB has extensive oil and gas experience advising on commercial transactions, including the successful delivery of the multi-billion-dollar alternative funding agreement and the divestment of 7 onshore oil mining leases in SPDC JV. She has managed a variety of complex legislative, regulatory compliance, gas value chain issues, production sharing contracts, and joint venture operations and government issues as well. She supported pension funds, downstream oil product, gas distribution business, and stakeholder management. Is the immediate past chair of the legal subcommittee of the Oil Producers Trade Session of the Lagos Chamber of Commerce, where she coordinated legal support for advocacy efforts in the industry. She is an exemplary leader with passion for people's development and an avid mentor and coach. Welcome, KB. Thank you for being with us today.
Thank you very much, Richmond.
Our next panelist, Taiwo Additional. Taiwo is a partner in the law firm of Jackson Etti Edu. He heads the corporate commercial department of the firm, which houses the firm's labor and employment practice. He is also the head of the energy and infrastructure sector of the firm. Taiwo's expertise in labor and employment law is born out of a strong dispute resolution background. He has a very strong understanding of labor and employment landscape in Nigeria, as well as international best practice. He routinely advises local and international clients on organizational matters relating to restructuring, employment restructuring, labor and employment collective bargaining agreements, human resource policies, amongst other matters. He obtained his LLB from Lagos State University and his BF from Nigeria Law School. He also had an LLM from University of Dundee, UK. He's a graduate of the London School of Economics, where he bagged a certificate in international commercial litigation and arbitration. He's a member of the Association of International Petroleum Negotiators. He's a member of the Nigerian Maritime Association, and as well as a member of the Business Recovery and Insolvency Practitioners Association of Nigeria, amongst others. Is ranked as a very highly recommended lawyer by the IFLRO, as well as welcome, Taiwo.
Thank you very much, Richmond.
Mrs. Rabi Adetoro. Rabi is a dynamic and strategic HR leader, currently heading the human resources at Momo Payment Service Bank Limited and MTN's fintech subsidiary. In this role, she collaborates closely with business leaders to ensure the presence of skilled and motivated talent, driving the company's mission of financial inclusion in Africa's largest economy. With a strategic mindset, she aligns HR strategies with organizational goals, leveraging a diverse background in sectors such as financial services, fintech, technology, telecommunication, and FMCG. Rabi's commitment to continuous learning is evident through certifications and training across continents, including obtaining certificates from the John Maxwell team. She is a global certified trainer, HR professional, and holds an MBA in human resources. She excels in crafting HR strategies, stakeholder engagement, employee experience enhancement, talent management, recruitment, data-driven decision-making. Her achievement has earned her recognition and awards, and she actively mentors aspiring professionals. Rabi's education extends to volunteering with organizations such as Pregnancy Nigeria, RISCA, to mention but a few, which helps in supporting women. She invites like-minded individuals to connect with her to unlock potentials and drive positive change. Welcome, Rabi. All right, so as you would say, our speakers are drawn from the judiciary, from human resources, from in-house as well as external. And that is to tell you we have brought in seasoned experts to share their words of experience in this particular issue. I will now pause and allow my Lord to give a general overview on the issue, the world of work. The workplace today has so many forms of work, different from what we used to know. And there have been lots of changes that have been happening, which employers and employees need to keep abreast of. So, my Lord, what are your views? What are the general issues surrounding the world of work, and what do you think is the future of work?
Thank you very much, Richmond. That's been a wonderful time. This issue of the new trends in the workplace, shaping the future of work, is very fundamental because a lot of people are not yet abreast with it, so that we know that is a reality that comes to stay. So it's really how to shape it for the future that is very, very fundamental. There's no doubt that the world of work is undergoing a fervent and phenomenal change arising from the aftermath of the COVID-19. So everybody knows what happened at that period. And then the current realities of economic downturn in Nigeria, particularly with the removal of subsidy and then the downtrend of the Nigerian currency, the international market. So a lot of things have really happened along line the labor system. But then the reality is here. And then the issue is how do we see these emerging variants of workplace realities. So it is our time to really look at it critically today and see what exactly it is, the legal issues surrounding the issues of the work models emerging in the modern time, particularly in this challenging time, as for employer and employee, and then the general economic system. Then what we have noticed is that there are variants that are really emerging, and prominent of which is remote working. So remote working is just one aspect of the emerging trends. And this webinar will actually focus on the concept of remote working and legal issues arising from it and other challenges which our colleagues will really deal with in details. So one of the aftermath of this reality is that a major variant had emerged in the workplace model known as remote working or virtual working or working outside the main station. Conceptually speaking, remote work connotes all forms of working outside the supposed workplace. I chose my words very well. So supposed workplace. We are not working where you ordinarily should have worked in a traditional system. That means that is remote. So I want to make that distinction so that it wouldn't look like all remote work are virtual. Now, not all virtual. Because what is said here is that when somebody is working out at home, for instance, he's not really working virtually, but he's doing deliverables and meeting up timelines. So that is one of the things we must look at in concept of remote working, that it does not really mean working in the system. It means you are actually working outside the physical environmental control of the main work at the employer. So it mainly involves working outside the employer's controlled physical environment. So remote work is usually performed at the environment not solely provided for by the employer. It does not necessarily mean platform workplace, which is usually digital in nature and controlled by the employer's online devices, such as e-hailing companies like Uber and Bolt, and other digital controlled app-enabled workplace platform. When we talk about remote working, it does not necessarily mean platform workers. What we're looking at is remote working also includes it, so it's larger than those platforms. So that's the main concept we'll look at. So we have seen that at this model, it connotes working from anywhere other than from the employer's office or designated place where the employer had the full control. It includes the digital platforms are using and including working from home or out of station-based working, all forms of flexible working arrangements where the employee or occasionally take charge of where he stays is classified as remote work. Then the legal side of it actually comes into play because it comes with it some level of legal implications that we're really grappling with and discussing in this program. So if you look at it clearly, we'll see that the worker is modified in the traditional sense, as well as the employee, the employer, because remote working, an employee can provide his own tools and even place of work, yet working for the employer, who controls the activities of the employee in terms of work assignment, remuneration, and disciplinary measure. These are the indices. So when you have the work assignment, you are the one that gives instructions and give rules of conduct activities, and remuneration comes and flows from there, including disciplinary measure, to be meted if you fail to comply with the work schedule and work rules, then that automatically falls into this concept. So once these elements are present, it is immaterial that the employer does not have control of the environment of work. So, we needed to get this concept clearly so that as we proceed, we will not confuse remote working with any other form of working, or begin to look at it from the point of view that the person is not actually a worker or an employee in the real sense. He is. So once these elements are there in control form, then that person is working. And if he's working, then all rules of engagement actually have to apply, for the simple reason that I'm delving into liability issues. And when you get to liability issues, you begin to say, no, he really is supposed to be liable, particularly when you come into the issue of workplace injuries that we're going to get into now. So where is the workplace? Who really owns there? You really have control. The control is not focused on the environment of the work. The control is focused on the assignment of duty, the remuneration, the discipline. So if these elements are there and there is no control of work environment, that does not make you not being an employer for the purposes of this discussion. So although this model has really endeared itself and become attractive because of its low cost management profile and being something flexible. So it's embraced by both employer and employee, particularly in a situation like this. So instead of you travel long distance or burn fuel on the radio, so you could as well work from home or other places of designated a place of work or tools to use to work without coming to the office fully. Then that has been embraced by both the employer and employee in recent time. But then it needed to be understood clearly in order to fully be integrated in a model in the emerging world of work and shaping the future of work. So major legal thrown-ups or legal issues thrown up by this concept includes injuries at workplace, unionization issues, privacy and confidentiality, migration control, and tax issues. I will just briefly highlight a few of them because we're going to get into them in full details. For instance, if you look at the injuries at workplace, just recently, Nigeria ratified 2 major ILO conventions relating to injuries and harassment at workplace. And that's the conventions C187 of 2006 and C190 of 2019. Both conventions were recently ratified by Nigeria. So the C198 of 2006 is a promotional framework on occupational safety and health, which was ratified in Nigeria by Nigeria on 8 November 2022 and to enter into force on November 8, just barely a few months now. It will enter into force fully. It is anchored on Convention 155 of 1981, that's Occupational Safety and Health, and Recommendation 164, which Nigeria ratified on 3rd May 1994. The aim is to say, as is set out in Article 22, is to enjoin member states to take steps towards achieving progressively safe and healthy work environment through a national system and national program and on occupational safety and health by taking into account principles set out in the instrument. So in other words, what it's trying to get into is to get a full framework of control of workplace injuries and healthcare. So the workplace here means wherever the person is working. So from what we have defined it means that even though an employer cannot provide the workplace, but is also by this convention liable to oversee what happens in the environment of work. So that's a very onerous burden of relationship now imposed by this convention. And Nigeria has just signed it off, and then it's going to take full effect from 8th of November this year, 2023. If you look at the other second one, which is Convention 190 of 2019, that's on violence and harassment and eliminating of gender-based violence in workplace, GBV. That was the one that also came in, and Nigeria quickly signed as the 4th African country to sign in and 8th in the whole world to ratify the convention. So it is actually a very landmark convention because it deals with almost mundane but recurring issue of sexual harassment, workplace harassment, and misbehaviors that are rising in workplace, not necessarily between employer and employee, like we see in the lecturers system where lecturers will start harassing students sexually, and the students are not necessarily the employer, co-employees, but it is a workplace issue. And these are the part of the concept that I want more people to understand, because even when litigation comes up, you don't see them coming to industrial court to really take that issue seriously. If you look at it, even an employer have a right to deal with an employee who brings bad reputation to the organization because of misbehavior arising from harassment and sexual violence in the office. A lot of bullying, a lot of compelling and compulsion, sometimes making somebody look like a slave, mainly because it's in the workplace or somebody is a senior in the office. A lot of things are being taken care of by the C190, which is well intended to deal with workplace dignity and respect. So employers must have a clear policy to entrench the culture of respect, and dignity of labor and relationship, and zero tolerance for harassment in workplace. So the ratification of this C187 and C190 has brought to for the 2 conventions within the purview of Section 254C2 of the Constitution, which industrial court uses. So that third alteration is with that. If you look at Section 254C2, the ratification of these 2 conventions have brought them into the purview of that provision of Section 254C2 for direct enforcement, as all ratified conventions in Nigeria relating to labor will become automatically enforceable without necessarily being domesticated as required in Section 12. Of course, I had the occasion to deal with this issue in Joseph Osaira against Shell BP, which I had to take position that once this convention is ratified, you don't need any domestication. and that will make it automatically effective. So Nigeria, a provision of Section 12 of the Constitution is quite different from Section 254C2, which deals with labor-related conventions that need only ratification, not domestication, as traditionally known by some scholars and practitioners. So it is automatic enforcement upon ratification. Then you see finally that the application of these two conventions have reinforced the enabling provisions of Section 254C1A and G of the Constitution, which gives an industrial court jurisdiction to deal with issues of occupational health, safety, and sexual harassment at the workplace. So industrial court is the place to litigate and deal with issues arising from these conventions and the associated issues of harassment and workplace injuries. Workplace includes remote workplace and also the physical place of work as normal one we know. And whatever happens there is within the operational legal regime of the conventions. So being not in control of physical environment in remote working will not exculpate an employer from liability on these issues. So even if your colleagues have traveled together abroad or somewhere else, and this issue arises from where they have gone, then that place is also a workplace for the purposes of these conventions. And then the organization is liable because the law is very clear on it. The liability is based on negligence. They say you owe a duty of care as an employer. And if you fail in the duty of care, then you are liable. So how these employers can actually grab with this distance relationship and monitoring what happens at those places and taking care of the environment such that the employee cannot get injured in workplace or get harassed or intimidated at workplace is actually an onerous one. And organizations will look at it how they can actually bring in such control to ensure that they minimize the liability arising. It would seem that an employee pressing claim for harassment at workplace injury will have to discharge the onerous burden that the employer is a negligent breach of the duty of care owed him as employer to protect the employee from acts of violence or harassment or even workplace injury. So if you take a staff like those working in a rig, that's a place of working in the rig, for instance, is an office, is a workplace, and injury arising from there definitely comes. And even if the person stays in his own house to work, then that is why you need inspection to find out exactly how that place looks like and whether that place is fit for the purposes of coming out of this scenario. So similarly, an employer can press claim against an employee who engages in disparaging or violence or harassment that would expose the employer to adverse claims and potentially image damage. So that would have said that it's not just left for the employer to be the one that's on receiving end. This is for all of them to be involved. So the future of remote working lies in greater control of activities of the employees at workplace. Research lies on setting up workstations. Looking at the workstation where employers will look at the remote areas where their staff are there and put a station where they will go there and perform their duty physically and go back without necessarily staying at their own houses. So this is like a template paper that will be expanded more. But a workstation is a part of the future of the world of work in this area. So where you put in a workstation within some areas, satellite towns where your staff are, and then they will converge at that place and perform their duty and then transmit the rest, particularly treatment of fires and dealing with emergency work should be done there instead of queuing at the traffic and spending so much money on the road. Or being worried with what happens in the person's own home and other tools. So on issue of privacy and confidentiality, to also know that there is need to balance rights of employees, privacy and confidentiality of employers' transactions done in remote workplaces. So these are the legal challenges coming in there, how to balance the rights of employees' privacy in dealing with this without being bogged down, without being supervised, but then the confidentiality of the employer's transaction is also important. While the employee deserves protection from their unauthorized bugging and intruding into the privacy, such as forceful unauthorized access to the phone calls, phone content, emails, and even work tools being used or supplied by office. So being supplied by office does not mean that the office have a right to go through it at all times. So the employer deserves a dignity and also contractual obligation to maintain confidentiality of his business secrets and in possession of the employee. So basically, non-disclosure agreement will come on board quickly so that a lot of things will be captured into this new system. And then you'll be sure that people don't just divulge secrets, or because they were always around other places that don't have control, you now have to lose sleep over what they are doing, where they are doing, or the type of people they are dealing with, including competitors. So then one of the research I'm proposing is to ensure that this use of notice salary in lieu of notice is not often used. Embrace notice period, so that when the person is to be terminated, you work within the period, and then there will be a proper handover. Those termination with immediate effect had this tendency of the person carrying the work tools and everything away, and then you'll be chasing the. I recently had this issue in the case of Guinness case recently, where the also against Guinness. The guy took the computers away and claimed that because he was not even away when he was sacked, he couldn't return the work tools. That spent almost long time before the whole litigation process take place. So this is not good enough, because once you say you terminate with immediate effect and then you pay salary in lieu of notice, you also having a challenge that the proper handover will not be there. There was an English case where an employee was not said they have not returned the office phone. And in the case of not returning the office phone, they had to bug into the mail to find out what they're doing, and discover that even dealing with his competitors. Yeah, the court held in England that it is not good to bug the employee, because they still have a right of privacy even when in possession of the work tool of the employer. So this will eliminate temptation of intruding into privacy. So unionism is very clear, because the law allows union workers to come in a platform of unionism. And then is irrespective of whether they are platform workers or they are remote workers. The important thing is that it is a fundamental welfare scheme for workers to collectively bargain with the employer and have a social engagement along that line. So it is Nigeria as a signatory to conventions on that, and there's nothing wrong in unionization of employees. So if you look at the migration issues, there's this challenge of the employees. The government, let me put it that way, to actually know who is in Nigeria working or who is outside working or who is working from where. So that's one of the challenge of regulators on a remote work model, because it does not give regulators full control of knowing where somebody is working from or what actually the person is doing, particularly on tax implications and visa issuance and immigration policies. So you can say you stay in your house and work in America, well, you don't know anywhere, you haven't even applied for visa. So that's for the regulators. But the most important thing is, if you look at it from the legal perspective, then how to control capital flights from the country is very important in regulating that aspect. So taxes are also done in that way, particularly personal income tax, which requires that the state of the residence is where the receiving authority of the personal income tax, which workers pay for the purpose of their income tax. So if that happens, that nobody actually know the states where these persons are working from, and then the states are losing revenue because the taxes are not well captured because of the PITA rule, that is by residency policy. So where you are residing is where that you pay. So constant movement of staff or working in remote area or remote platforms actually affect due tax revenues, and employees' resident status may often mutate and change that to the extent that we will not even know exactly where it is. So with all these key notes, I think it is time to set the tone for full discussion with my colleagues who are already agitating and eager to have their shots on it. Thank you very much.
Thank you very much, my Lord. My Lord has dealt with the topic holistically. And I will just, before I come back to my Lord, I've pointed out some things, confidentiality issues, the remote work and platform work, immigration, tax, so before I come back, I know that also participants are eager to ask some questions to also get more clarity. I will just, Rabbi, my Lord has basically set the tone for this discourse, and there are issues concerning talking about any place outside the four walls of the office can be taken as a remote work location. So where this happens, that employees work outside the office, how do you handle or manage a situation of confidentiality and productivity? How do you ensure that people are accountable and they don't just go out, maybe watching movies or that during the period of remote work? So, yes,
all right,
Rabbi.
thank you very much, Richard, for that question. And my Lord has done a good job just creating a background of what work from home or remote work is all about. And when you talk of the issue of productivity, it's a very, very thorny issue. And honestly, if you ask me, apart from the commercials, that's what keeps most business leaders awake. You know, the question of what if? Are they working? Are they in the market? Are they shopping? What exactly are they doing at home? And that's where the issue of productivity comes in, because I've actually been on Teams meeting where people are mute and you can hear someone pricing okra. I mean, that's a joke we have around here. We're in a meeting and someone is saying, how much is this okra, right? So you have a few of those examples, and honestly, it's a dilemma that we need to reconcile. But what I advise people is, let's not stay fixated on what ifs, but let's do what is within our control. And the way we can manage productivity is, first of all, to eliminate the biases, because there are a lot of biases that exist regarding this remote work. And the initial one, I mean, the most common one is the issue of the proximity bias. We have a lot of managers that feel if people are not in the workplace, then they are not working. And so it's so difficult to erase this bias. Whether you like it or not, they're going to tell you, bring everybody back to the office. And that's a mindset shift that we've been trying to achieve in organizations, to say that gone are the days where you were in the first industrial revolution, where you had to count the crates of water that was produced, where you had to count the tubers of yams that have been produced because you needed to see the people. Now we're dealing with knowledge workers, and what is most important is the outcomes, not outputs. You know, so those are very key words, and they must be emphasized. There's a difference between output and outcome. The output is the presenteeism. That means I'm sitting down here. I clocked into work by 8 p.m. I have turned out this, but the outcome is what goals were set for you. Have you achieved those goals? And that's what we should focus on in terms of measuring productivity. And a lot of training is required, because we're all human beings and we live with biases every day of our life. And I talked about the proximity bias. There's also the confirmation bias, which means that I will try my best to ensure that I have examples to show that remote work doesn't work, and therefore people are not productive. So there's a lot of mindset shift. There's a lot of training required from leaders, from line managers, because at the end of the day, when you talk about productivity, the key players here is the line managers, is the leaders who are monitoring people. If they remain with these biases, then we can't have a productive workforce, because there's always the issue of trust that comes in and doubting if people are working. In conclusion, I would like to add a very, very, very important point, which is around goal setting. We have to move away from the traditional approach of performance management, where goals are set annually and performance is reviewed on an annual basis. We have to do it more frequently. And of course, for line managers, we've seen that that's a very painful process, where you have to measure performance on an ongoing basis. We're not used to that. We're used to the annual performance cycle, or the 6 months, where you wait for a whole year, and at the end of the year, you have a conversation with your team members. But now there's a lot of retraining required in terms of ensuring that performance is managed at shorter intervals, perhaps weekly. There's also the importance of setting very clear goals. We can't have goals that are ambiguous anymore and unclear. They have to be very clear to the last detail, so that we're able to evaluate those, on a more regular basis. So in a nutshell, it's really about eliminating those biases. And for us to eliminate biases, we must train line managers to help them eliminate those biases. We must train line managers on how to set clear, smart goals, how to evaluate those goals at more regular intervals and not wait for a long period. And then also help employees understand that there are no biases and that outcomes are important. So have you been given a task to do? Have you turned out that task in the manner that is required? Once we have all those interplay working together, productivity will be improved in organizations. For the issue of confidentiality, I'll just touch on that briefly. For confidentiality, because we've come out, and my Lord, he alluded to that we're no longer in the bubble that is secure, which is the workplace. We are now working from home. So it means that the traditional approaches has to change, and IT in every organization becomes a key stakeholder to ensure that there's also security applications installed on laptops, computers. The issue of people using their personal devices needs to be checked. And for my organization, we've limited that a lot because we can't install all the security appliances on personal computers. But where organizations allow people use personal computers, then a lot of security applications need to be built into that so that information remains confidential. And then finally, there's also need for IT to ensure that certain information, certain documents cannot be accessed from outside locations. So a lot of stuff, work around that needs to be done to ensure confidentiality and also manage productivity for organizations.
Thank you very much. And I just want to take you on some of the points you raised concerning deliverables. Where the employee is working in a different time zone, for example, how do you manage those kind of situations? How do you measure the deliverables? What are those things you can put in place in ensuring that there is still that productivity and the goals already set are being carried out?
Okay, that's a good perspective. And honestly, whatever location you're working out of, performance management doesn't change. It's still the same principles of effective goal setting, effective coaching, and follow through. Because there's a ratio that organizations can use, and it is work done versus work completed. So you have a set of 4 people, whether working in Asia or North America, and you've given them tasks to complete. By the end of the month, you can measure the work assigned versus work completed, and that shows you who is productive and who is not. Some people might have occasional slips, or when it becomes something that is consistent, whereby you're given 5 tasks to do. And again, I'm going back to the goal setting. The goals have to be very clear and smart. And you have a set of team members, and 3 out of the 2 members are delivering 80% of the goal set, while 1 consistently delivers only 40%. Then there's an issue there, and that's where the concept of consequence management comes in, right? We're supporting you, we're trusting you to deliver, but if you don't, then the consequence management needs to kick in to ensure that we have the kind of productivity we want in the workplace.
Thank you very much. That's a very good one. My Lord has mentioned other forms of work, because when we talk about the world of work, it's not just the way we know it before, and things have changed, and even issues like triangular employment and co-employment relationship, there would be certain dynamics to it at this time. Taiwo, how would you relate those traditional forms or those non-standard forms of work that we used to know with the new forms that we have now, like remote work? What is the correlation, remote work, triangular employment?
All right, thank you very much, Richmond. Thank you very much, Richmond, for that question. I think it's a good one. My Lord, when he was talking, he mentioned the different forms of work, which is like the new order. And part of it, he did mention is probably maybe cost saving for the employers. In a triangular employment, I think what you would have is a situation where The businessmen really want to focus on the operations of the business. And to do so, they will want to push the burden of employment relationships and all of that to a third party. So what that means in simple terms is that a company is responsible for employment, of the labor force of a third party company for the benefit of that third party company. What do you have in such scenarios? You have about 4 relationships, I believe. One is the relationship between the end user and the recruiting company. That's the outsourcing company. That's a commercial relationship. You also have a relationship between the outsourcing company and the employee. In that scenario, what you typically have is the employment contract and other policy documents that they may have in that company. You also have a relationship. You also have another relationship between that employer and the employee, which is or maybe named secondment, and that's the instrument that then moves that employee from that recruiting company to the end user. That's one. And then there's a fourth relationship, which will then happen when that employee goes to the end user's entity to work, right? So the question is that something that is recognized within Nigerian labor law or labor relations? Yes, it is. So if you look at a couple of legislation, and I'll say you go to interpretation sections of those legislation. One of them is the Employee Compensation Act. The second is the Labor Act. And I think the third is the Pensions Reform Act. If you look at what employees mean as well as employers, you will know that legislation actually do recognize the concept of triangular employment, where a party can actually employ a workforce for the benefit of a third party. Also, the National Industrial Court have also alluded to the fact that that is not an unfair labor practice. It can be done. And I think that was decided in the case of Tengasan and Mobile Producing Unlimited. The question now is, if there are issues, there are disputes, between that employee concerning that nature of employment or the structure of that employment, who is liable? Is it the end user or is it the primary employer? The simple answer to that would be, on a general note, it should be the employer, and it will be the employer under the concept of privity of contract, right? But there are times that privity of contract can be removed as a shield, for the end user, if for any reason that structure is seen or considered or came out as a sham. What do I mean by a sham? If it wasn't for a clear purpose, a sincere intention to achieve the things I mentioned earlier on, to allow you focus on the business objectives, as opposed to burdening the business with what goes with employment relations and what have you, then the court can look at you as a co-employer of that employee and then makes you liable. What are the things that will give away end users of this nature? I think there are about 4 of them that I can think of right now. One of them is employment, the recruitment of that particular staff. The court is going to look at it and see whether or not you are involved in that recruitment of that particular person or those persons, as the case may be, and what involvement do you have in it? Do you have a final say on who is recruited? On who is recruited? So you have to try and move away from that. It's not your business. What you have is pure contract for service with that recruitment company. So that's one. The other one that may give you hope is on supervision and direction, right? When Rabi was speaking earlier on, she mentioned performance appraisals and all of that, and it has to be like something that is constant, that you don't wait till the end to do it. If you fall into that ditch of appraising employees or setting goals for them when they are not on your own payroll, then you may be exposing yourself, to liability when there are issues with that employee, right? Issues concerning the holiday, concerning the person's benefits. Some companies are magnanimous, they give like meal tickets for lunch breaks and all of that. You consider everybody as part of the people on the premises and you just give like that and all of that. When they start to take benefits, do you understand, from you, that ordinarily should not come from you to them as employee, they may take an advantage of that or take advantage of that to say, look, you are a co-employer. Disciplinary actions as well. You don't want to if you're not satisfied with the workforce supply to you, the best we can do is to complain to the other company that outsource those employees to you and let them do it or treat it the way they deem fit or supply with other stuff. But if you, for any reason, got caught in disciplinary action against those employees or make communications that would ensure the termination of their employment and all of that, you can be exposed to what is called co-employment, and those employees can actually sue you. So by and large, those are the issues around triangular employment in Nigeria. I think that there's nothing wrong with it. The courts have said that there's nothing wrong with it. But when you then go beyond, you now start exerting control over these employees, then you can be seen as their employer. And I think NIC also haven't said in the Pengasan versus Mobile case that, look, there's nothing wrong with it. It's part of the new ways of doing things and is accepted. In Ayago's case versus same Mobile, the court said, look, this is a sham, right? And we will not allow it because the company in that case went beyond what they should be doing, you know, as an end user, you know, as opposed to an employer. So that would be my response to that question.
Thank you very much. Just a quick one before I allow you take a cup of water, a glass of water. Let me go on with just a quick one on occupational safety. I know my lord that alluded to the conventions that have been ratified by Nigeria, and as we know, they now form part of the jurisprudence. And at the moment, employers would need to start thinking of ways in ensuring that their workplace policies are in compliance with the provisions of the conventions. Otherwise, it creates certain form of exposures. So what do you think are those things that employers should bear in mind in terms of workplace policy in ensuring that issues on workplace occupational safety and health are taken seriously? Just briefly, maybe within a minute or so, you could quickly respond on that.
Okay, thank you very much. I'm not sure if you were looking at me. I was smiling when my lord was saying, you know, that workplace is beyond the physical office. You have to then also be in control of what happens with respect to where those employees carry out their functions. He mentioned co-location areas and all of that. He also mentioned working from home. So my view is the work safety and health convention, I think even though it was recently ratified, I think Nigeria was ahead when it came out. And if you look at the contents of that convention, right, the ILO Convention on Work Safety and Health, you would see that a country, you know, a nation as an entity has an obligation to do with respect to work safety and health of employees in a workplace. And I think Nigeria has not done badly because we have the Workmen's Compensation Act, which details what would happen when there are issues. I'll come back to that very quickly. But before I come back to that, when you then work from home, it becomes an issue as to look, what is the level of responsibility and duty of care that the employers have, you know, within your own private space at home? The question is the person functioning, or has person got injured or got infected in the course of doing that business? Previously, the NIC has held that if somebody is traveling from his home to office, that is also in the course of business. If the person is moving from office for his lunch, is in the course of business, and if anything happens to that, that falls back on the company. But at home, how do you do that? I think that is a very tough one, because you can't go to every home and be inspecting the workstation of the employees, depending on the size of your employees, to say, look, okay, this is okay, tick, 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 you can work from this station. If it changes, how would you react to that? So I think, in my view, the best way to treat that is to have a policy document, just like the country has, right? I'm sure there's a legislation as well, the Work Safety and Health Act of, I think, 2005, if I remember, and then the Employee Competition Act that I mentioned. So the government has done its part, but you as an employer need to have a policy document that would ensure that the rules are clearly set on how people would work at home, what the workstation should look like, without you physically intruding into their privacy to say, no, your table is not right, no, these cables are flying around, it can trip you and all of those things. So if you have that policy document and anything happens, and it is now shown or found that the employee did not follow those set rules as comprised in your policy document, then you can be exonerated from such liability. But if I come back to what I said earlier on with what the country has done as a nation in furtherance of that convention, so if there are issues, the employee has an obligation, or the guardian of the employee, to inform the company within a certain period of time. I think it's 14 days, right? And then the company has 7 days to inform the NSITF, which is the custodian of the funds, the NSITS fund, as Nigeria Social Insurance Trust Fund, for compensation of injured or diseased or dead employees in the course of their employment functions, right? And so you do that. And I think when you inform them, you also need to make an application for that claim, right? For the claim for compensation for that employee. And if you're doing that, it's expected that you do it within 1 year and the decision is made, but there's a gap for you, or what would I'll call it a grace period of 1 year to 3 years. If it is seen that, look, it was impractical for you to do it within 1 year, then you can do it within 3 years. But essentially, that's what the nation has established as the procedure for getting those claims. But you as a company must also put policy in place that would follow trends to ensure that those go out there. Thank you.
All right. Thank you very much. Riding on that, my lord, remote work and injuries at workplace. I know you spoke about it during your keynote address, but sometimes it's unclear when to draw the line and when you will say, oh, this injury actually happened while at work, particularly where the remote work is a kind of a work from home arrangement. So, and Taiwo has mentioned, how will you start inspecting houses and all that? You could put in certain measures in place. What if they change? How will you know? So how can you draw the line when there are injuries to the employee and it happened in a remote work? How will you draw the line to know, okay, this did not happen in the course of work, or it happened in the course of work? My lord, just briefly.
Yeah, when I was speaking at the keynote level, I was pointing to the future of it. And that future is having a satellite workstation where you remove the employee from his real home and place the person at a neighborhood office. That neighborhood office is what I call the satellite workstation. I'm telling you that in future, the real estate developers will look into that. Imagine putting up a very big office in Aja or in Besa or in Ikurudu or in CMS. Somewhere down, on those catchment, densely populated areas where the water commute from. And part of what they are doing in the whole idea is to save costs. The whole idea is to maintain health situation if there is a pandemic. So health and costs actually what led to remote working. And if you look at it clearly, if there is a big office which is being used by a certain group of employees in Nigeria, for instance, those workers coming from that neighborhood would not need to come to Victoria Land, for instance. So they will just walk in there, maintain your own, you equip the place, fix everything you want to fix. They will come there, perform whatever they want to perform, go back to their own main house. And then that is your workplace. But that's not your real workplace. Your real workplace is there in the heart of Victoria Land. But because of such challenges, they can just walk in somewhere like a cafe and then perform duties. So those who are in the field work will go straight to the field. Those ones are already in remote working. So remote working is not even new. in the real sense of it. Engineers actually are involved in remote working. They go to the site, and all the liabilities that are arising there will occur in law. So what I'm saying is that those administrative setup organizations that actually use computers and other things, and instead of you to somebody can clock into a system and then go to sleep, and automatically the computer is a dumb instrument. It will just pretend as if the person is there while the person is not. He has clocked in. When the time reaches, it clocks out. Just like the example is saying that somebody was pricing okra while they are in a meeting. So these are, when new phenomenon comes in, you use new methods to control. So you don't think that you have to continue the old way. So if you allow, I'm actually telling that working at home should not be in your home. And if you continue in your home, it will bring in too many. Let's look at the power spark. Just somebody is using the illegal lighting system in the neighborhood, and then electricity spark demand, and then something happened. You just got a call in your office that there's a problem somewhere. Your employee had been injured because of fire outbreak in the neighborhood. If you were in control of that, you would have done better. But this employee did not care.
Thank you, my lord, for that.
So that's the picture. The future is satellite workstations. That's the future of it, where they will go to some neighborhood, perform their work, and go back to their home, close to them. Then sometimes now return to the main head office if need be.
That's very, very key, and it's a very good point my lord has made. And riding on that, what if the employment or the employee is in a remote location outside of Nigeria? KB, I would like you to give your thoughts on that. Can a Nigerian who is a resident abroad, for example, or even a foreigner resident abroad, can he be working for a company in Nigeria remotely, now that remote work can be done anywhere? So what do you think that it's that kind of person or employee can still continue working for a Nigerian entity?
Thank you very much, Richmond. I think my Lord had brought so many things into the room by his keynote speech and all. So there are different variants of this. We're talking about there's working from remote location as different from remote working. So I think we need to be clear, because prior to COVID-19, from inception, there has been working from remote locations. You have field workers who need to be where the activities are going on. And then you have your offices. So you have office-based staff. You could have field-based staff. And each of those are work locations. But I think what COVID has forced on us is the new normal of remote working. So that distinction needs to be made clearly. Working from a remote location, that location is still the office, because that is where the organization carries on that specific businesses that are situated in those locations. But I think the question you're asking is about people working outside of jurisdiction for a company in Nigeria, for instance, or someone in Nigeria working for a company outside of Nigeria. Just to be clear, I understand the question.
Yes,
Richmond,
sure.
did you hear me? Yes. So again, that's a function of law, and then it also has tax implications. There are tax incidences of where you are located. As Milord said, taxation in Nigeria on income is governed by the Personal Income Tax Act. And the main basis for taxation is residency. And under Peter, it is where you are resident as at the 1st of January. And so what organizations do is you declare, you have a form, you declare are you resident as at the 1st of January. Of course, as Milord said, over the year, there are mutations, you move here and there, but I mean, that happens. You would have things that will take you outside of your primary work location. but it is always important to know where you are at the 1st of January, and that determines tax residency. So that's one key issue. Now, there are also different forms of employment, and that also determines what the incidences are. If you are a consultant, for instance, you could be consulting for clients outside of your jurisdiction if it does not require you to have boots on ground where the end user or the consumer of your services are. If you situate that in Nigeria, if you are offering consultancy services, for instance, so the end user, you may be exposed to withholding tax, ranging from maybe 5 to 10% consultancy fee, right? But when it comes to personal income tax, if you are a Nigerian company paying a staff, then you are an agent to the tax authorities. You are required by law to deduct the tax as such and to remit it. So you then see challenges, conflict of laws, and then companies not wanting to subject themselves to the jurisdiction of other countries. There is also the issue of double taxation, even for the employee. If, for instance, you're in Nigeria working for a firm outside of the country, that company may be obliged under their own laws to deduct certain taxes from your income. And so is that double taxation for you? Is there a tax credit? And so for that, you probably need a tax consultant to help you be efficient about your taxes. And if your company is not in Nigeria, for instance, you have an obligation because under PITA, you have to pay taxes on the income and whether from your services in Nigeria, out of Nigeria. You have to self-regulate, you have to register, you have to file your returns, you have to make those payments. So there are issues definitely that this throws up, besides the fact of compliance with relevant laws of employment, who can work where and at what time. So that then the nature of the employment or the nature of the services determines which law is applicable. So you can only speak in general terms in this context. So those are some of the incidences of remote working, one way or another.
Thank you very much. You have drawn our attention to a lot of things. And I think when you were speaking, part of what also came to my mind was also the immigration concerns. If a Nigerian has to move over and maybe on a different engagement. For example, you've gone on a business trip or just a regular travel, and then you continue working for your company in Nigeria. Taiwo, what would be your thoughts on issues of that nature when an employee maybe travels outside of Nigeria, is gone for a business trip or is gone for training or whatever, and he stays over for a period of time, and then he continues working for his company in Nigeria? Would it require a work permit for him to continue doing that?
Okay, thank you very much, Richmond. I think that's a very interesting issue that you have raised from what KB said. But let me backtrack a bit and go to what the situation was during COVID. And I think that's how some of these things started and is becoming like the new order in terms of work globally. So during COVID, a lot of people were stuck in whatever jurisdiction at the time was declared a pandemic because the airspace were short and all of those things and people couldn't move. I know of people who were in the UK, for instance, for like 7 months and all of that. They just couldn't come back, but they had to continue their work from there. So I think flowing from that, a couple of countries now have what is called digital nomad visa, right? Which allows you to stay in their country and then work for an organization outside that country. But like KB said, you know, what would then be the implication of that from a tax point of view will depend from one country to another. So I'll give you some scenarios based on the experience I have had. So tax generally, you know, particularly personal income tax, are probably assessed from 3 different ways. One is residency. I think KB spoke to residency. One is citizenship, right? And I think the third one is territorial, right? So on residency, most countries actually have residency as the basis of their personal, of assessing the personal income tax of people who are within that country. And a number of them actually have 183 days, like Nigeria, within a financial year. If you've stayed like 183 days and beyond in a country, then you are most liable to pay tax in that country. They will see you as a resident of that country, and then you pay personal income tax. So that's that one. The second one on citizenship. Okay, before I go to citizenship, I think for most countries who do residency tax base, right? What they also do is that they also assess you on your global income, which touches on what KB mentioned when she said double taxation. So if that happens, you have to then check whether or not there's a double taxation treaty between that country and your own country of origin, and to ensure that you are not paying a particular tax twice. If there is no double taxation treaty, then the situation may not be so pleasant for you. So the second one on citizenship, I think in America and Eritrea, right, they have their tax assessment based on citizenship, and it's also on global income, right? Once you are a citizen of those countries, you're expected to file your tax returns annually, right? And they will do that. The other one that I mentioned is territorial based assessment. So what those countries do is that it is only the money that you earn from their country that they will tax you on, right? But any money that you earn outside their country, they are not really interested. So going back to the digital nomad visa that I mentioned, that countries have now latched onto, there are about 58 countries now that have those visas. Some majority don't have yet because it's evolving. They have those visas. Malta, for instance, has. So if you're in Malta, for instance, you're allowed to stay, you understand, in Malta and work for your Nigerian employer. And you won't be obligated to pay any tax in Malta. What you then pay will be consumption tax, like every other person. I think that's the upside for them. You pay your rent and all of those things, put money into their economy, but you don't pay personal income tax for money earned with outside Malta. But you also have to show them that, look, you're paying tax in your country of origin, right? Evidence of that has to happen. In Portugal, another example, it does happen also. They have it. They have the digital nomad visas. So the digital nomads there, what you do there is, their own is based on residency. 1 in 3 days, they slam you with your tax, right? And their own is up to like 48%, I believe, similar to the UK, up to 48%, right? Depending on how much you earn. However, you can apply as a nomad there, is a nomad there, for what they call non-habitual resident status. If you do that, then they recognize you as non-habitual resident in Portugal, and then they can reduce your tax to a flat rate of about 20%, right? And they also will not charge you. I said that residency, they will usually go for global income. They also will not charge you for income and in Nigeria. They allow that. And I think there are other examples also. There's Georgia, but maybe because of time, I'll stop there. But essentially, this is very important. Essentially, this is speaking about it from the employee's point of view. But there may also be an exposure for the employer, depending on the status of that particular employee, which may trigger what we call permanent establishment, right? Permanent. If that happens, that means you may be obligated to pay corporate tax in that country. So, for instance, if your director lives in that country, is making decisions, signing contracts, and all of those, some countries have that. So, but like KB said, this is general overview. If you are going to be involved in any country other than your country, you need to still seek advice or tax advice from tax practitioners in those countries. Thank you.
Thank you very much. Thank you very much. The new concept, digital nomad visa, I don't think we had this few years ago, and COVID has really made a lot of changes to the way work relations are happening and being shaped as it is now, and that is still part of what is the next future. What are those other changes we're going to see within the next couple of years? And when you were speaking, something just struck my mind, and that digital nomad visa, does it contribute to the Japa syndrome, or does it ensure more productivity in the workplace. Rabi, would you give your thought on how will you ensure sustainability of business and then respect to issues on remote work, flexibility of work, mobility, now digital nomad visa? Do all of this, do they contribute to employee retention and sustainability of the business, or are there instability or uncertainty in the workforce?
Well, I like the way you wove the question in, especially regarding the Japa syndrome, because honestly, that doesn't help us. It's a new phenomenon that we're seeing, and honestly, a lot of organizations are bleeding. And to manage that and ensure we have a sustainable organization, it's very essential to have a bench strength, just like in the football match where you have players on the bench. So it's very important to always have players on the bench. And forward-thinking organizations need to put in talent management strategies that can help you ensure you have a fluid pipeline. You have a very deliberate succession planning approach where you've identified successors. And you must have a good retention strategy, because there's no point identifying successors and they're leaving every other year. So it's a whole talent management strategy that needs to be put in place by organizations to ensure that there's a retention tool that is working, not just on a strategy paper. There's also a pipeline that is fluid, especially at the lower levels where we're experiencing this Japa syndrome. But I must say that the concept of remote work from home and all is a welcome development. Because when you look at the workforce of the future, we're having a lot of Gen Zs. And it's not just a cliche, that's what's happening. And what the Gen Zs want is autonomy. They want flexibility. And that's what the remote work, hybrid work offers. And for me, what I recommend to organizations is the best of both worlds, right? Because I remember a lot of CEOs boasting, oh, we're going to flip the model, meaning that we're going to work 5 days from home instead of coming to the office. Or realize that that doesn't really work, because you lose the interaction, you lose the connection. There's also an issue of employees who are doing something else. You can't shy away from that. They need to be brought to the office. We have different categories of employees, and experience has shown us that not everybody can function working hybrid or remote, depending on the nature of work they're doing. So where you have customer-facing employees, they can't be sitting at home doing their work. A colleague recently told me about sales reps, people working and facing customers, saying that they want to work 3 days from home. And I was wondering, what are they going to be doing at home when you're supposed to be working with the customers? So it's clear that not every job can be done from home. And what is key is that we need flexibility. So those CEOs that said we're going to flip the model, the radical CEOs have now come back to say we can't flip that model. We really need the interaction, face-to-face meetings. We need the corridor talk. We need all that. So my suggestion is a hybrid work model where you work some days from the office, some days from home or from wherever. I also suggest flexibility in terms of, you can wake up and decide you want to start your work by 9, because I'm an advocate for ensuring that the bias of proximity is reduced as much as possible. But we must have core hours, and that's the flexibility. While we say you can work the hours you want to work, but there are certain hours in the day that everybody must come to the party. We must check in with everyone. So it's not you going off and doing your own work the whole of the day. There are core hours where everybody meets, even if it's virtual, and we have a meeting and we check in. So that's very important. In terms of sustainability, again, we know that a flexi work approach allows us to attract talent, and that's what organizations want. I was reading an article recently that was letting us understand that oil is no longer the future. Money is no longer the future, but availability of critical talent to do the job is the future of work and of organization. So for us to have a sustainable organization, we must inject flexibility into that organization. We also know that when employees can work from home, we reduce carbon emission and all that ESG goals. So diversity, ESG, we can achieve that using this model of hybrid remote work. And honestly, it's the way to go, but we must ensure that the right checks and balances and flexibility is introduced into the model that we want to practice in organizations.
Thank you very much. That's a very good one. I think when we talk about work from home, remote work, it's all about employment relationship, and employment relationship starts with recruitment, managing, and sometimes it also comes to an end, or it would come to an end, whether by way of retirement or resignation or termination. So, and when an employee, a remote employee, is terminated, for example, KB, what happens to companies' properties and confidential information? I know my lord has mentioned that it will not be advisable to terminate with immediate effect because it could create room where the employee go away with company property and all that. But sometimes you can even give notice and the employee can still go away with the company's property. So how do you protect and sensitive information? There are cases where an employee threatened to divulge some kind of confidential information if certain things are not done. These are life scenarios. These are things that have happened. So what are those measures that employers should put in place in ensuring that companies' properties, confidential information, and documents are protected even in the event of termination?
Thank you very much, Richmond. Let me just start by saying that the issue of, for instance, an criminal disengagement and what happens to it, whether you're in the office or you're working remotely, those challenges are there. Breach of confidentiality, misuse of confidential information, whether you're working in the office or you're working from home, they are there. But one key thing is that remote working increases the risk. That's what I would say. It increases the risk because, for instance, even when Milord said, utilize notice, there are situations where you cannot but have maybe the summary dismissal or termination. When the staff is in the office, it's easier to call the staff into the office, into the manager's office, have the conversation. You have security men downstairs, you retrieve company equipment and IT equipment, and then they escort the staff out. But when you're remote working, the staff or the employee has those equipment with them to enable their working remotely. So what do you do? The fact that a staff is working remotely does not mean that you do not have that physical connection. You probably could invite the staff. Now, if it is a mutual disengagement, if it is a retirement, if it's a resignation, or even if it's a termination with notice, you would have had conversations with the staff, and there are expectations. And you would invite the staff, and the staff would come in, and you would do your normal offboarding. But what organizations also do is, no matter the form of disengagement, you want to say payment of final entitlements will be made when you return company property. That's one way. But whether the staff would oblige, particularly in an acrimonious disengagement, is another thing. But that is one sure way. You ensure that you bring the things that you need to return, and we'll compute and pay you off mutually. We say thank you and goodbye. Does it happen like that all the time? No. So there's always that delta, the situations where the disengagement is not as it should be. So that you would need to deal with. And I think it is those sort of cases that go before me, Lord, and he has to deal with it and enable the parties to come to terms with what needs to be done. But when it comes to confidential information and the risk associated with the return of confidential information, misuse of confidential information, that again is exacerbated by remote working. And this can be deliberate, or it could be inadvertent, or it could be pure negligence. When you're working in the company's offices, it is somewhat a controlled environment. You have structures in place for at least managing who goes where. Depending on the sensitivity of the transaction you're managing, you could be in an open plan, or you could go to designated meeting rooms to have your meeting. You could use company printer, encrypted, ensures that you take out only those who have a need to know, have access. But when you're working from home, inadvertently, you may be exposed to a breach of data protection or confidentiality. Why? Because you are in your city. If people now have home office, as they call it, and which is what we encourage, have a designated place, which is your office, and let your family know this is office. Because you're having meetings. Even if they're not hearing the party on the other side, you are speaking, and they are commercially sensitive information. You have visitors and guests at home. Inadvertently, they may be competitors to your organization. And so you're here having meetings. So before you know it, there's information leakage. But again, what is important is having the right policies in place. Making clear, I mean, you have information security, information management, and all of that. You put those in place is part of the policies. Employment is by contract. And contract is not just the contract of employment, it is all of the policies of the company. And the same as are amended from time to time. And you would agree with me that COVID-19, remote working, working from home, no matter the variant, has foisted on us a new norm. And so companies are adapting, companies are innovating, companies are reviewing, where are my weakest link? And data privacy, information management, information security is one of those areas. And as the ILO said in their latest, in their employer's guide on working from home, these things require working from home and managing it. The way they had put it in the guide for employers is that it requires a shared responsibility and commitment by both employers and workers to make it work, to make it successful. And I was glad that when Milord was speaking, he talked on the employer's responsibility, but he also talked about the rights of the employer. And it's gratifying to know, because when these breaches occur, and if we have to litigate, we're coming before the National Industrial Court, and we're looking to the court for consistency in application of these rules. There are expectations from the employer also. So you have policies, you choose to work with this company, then you choose to obey the rules. And there should be consequence management and implementation of it. So that helps, because where there are no consequence management, that people do not know that these things and the breaches of them have consequences and they have implications for the company. So you must have your policies in place that very clearly states how you should work, what you should do or not do with company property. That's very clear, so that when there is an abuse, it will not be for lack of knowledge. And what companies are also doing now is moving from where you have shared devices, personal and company, to ask for separation. Keep your personal life on your personal devices, where possible, so that it's easier. What is stored on company equipment remains company equipment for easy retrieval. Again, it's been said severally in this webinar, the IT support is quite important, because most of the protection that you can put around information security and all that is IT driven. And so you have seen companies installing softwares on company equipment that limit activities that can be undertaken on those equipments, transfer of mails, copying of information from the equipment to other non-company devices. You know, you now have encryption, you have protection that ensures that you're not able to transfer easily. But we know, of course, when you're remotely working, there are different ways. You could take your camera, you could take information. So that again requires commitment. And where there is a breach, there is consequence management to be applied. Use storage of information on the company's server, and ensuring that whatever you do is done within that web-enabled or IT-controlled environment. So those are some of the things that companies can do. By the end of the day, it requires that commitment.
Thank you very much. I think you've spoken to also the downsides in remote work and some of the challenges employers will face, and the measures that could be put in place in ensuring that those issues are mitigated. But then sometimes we cannot control how some of these issues may end, and they could eventually get to the court, and the court has to decide one way or the other. If I would ask my Lord to just share his thought on what possibly should employees bear in mind and employers have at the back of their mind in ensuring that matters on remote work, where there are termination or where there is any claim and all that, what should the parties do in ensuring that these issues could even be resolved without going to court? Or when it's in court, what can the successful party, what are those things that a successful party should put in place or bring before the court in ensuring that they win the case?
Yeah, thank you, Richmond. You see, the issue of remote working and working from home generally, or working out of a station, when it comes to retrieval of sensitive documents or controlling of confidentiality after termination, is a sensitive one. And many a time they leave it until after the whole hog of the litigation that naturally will take longer period, without initiating some preliminary steps ahead of litigation even. Nothing stops an employer, for instance, from seeking an interim measure from the court while having a major dispute from, with a sensitive employee, by asking the court for an order to bring forth certain documents or anything and keep in the custody of the court while they are taking some steps in actions, or even restrain him from doing certain things inimical to the interest of against the interest of the organization. So if, for instance, a particular staff is very sensitive, he has key information, of course, look at even the ICT people. There is a dispute involving an ICT person who has the full password and all the whole encrypted system you thought you have done well is in the hand or knowledge of this person. And then we are having issue with him, for instance. You know, is the person you depended on to handle your security controls of all those things, yet you have issue with him, for instance. If you don't come to court to seek interim measures of protection, you will not be able to get full value from the exit of such staff in acrimonious manner, because the staff had so much information, so much control, that the organization is actually at the mercy of such group of staff. Those are the people that are in ICT, there are people that in sensitive commercial area, some also in operations. So the employers are always looking at the court from the point of view that is the employees' court, like NIC and have been previously viewed. It is not correct. What is correct is that the court is meant for both sides. So if you have this type of scenario where your sensitive information or confidentiality is being threatened because of the acrimonious relationship with a particular staff, nothing stops you from approaching the court for interim measures of protection. And the court will gladly look at it and hold it even as an emergency proceeding. So it's not like you are looking for 3 years, 4 years proceedings. So these are the differences between this industrial court that practice almost like arbitration, you know. So it is not this way people are viewing it. So they should also view court and litigation from this new measure, new normal, particularly industrial court that had this proceedings done in a very fast track system. So it is not you looking at it from go to court means you are not going to get justice. Go to court means it's an employee court, or go to court means a delay, and this, that is not, it doesn't. So we have well-trained, well-scholarly, known judges and staff that don't give room for that kind of oppression. The employers are also oppressed. So if you feel oppressed, the court is there for you to take advantage of the law. So the law is not meant for one side. So I've deliberately argued that everywhere I go, that it is not true that it is all about employer. There are a lot of issues here. For instance, a damage. This violence we're talking about, a particular staff behaves in a way that exposes the organization from what stops university, for instance, even from taking a suit against the lecturer that was involved in a scandalous relationship with the staff. a female student, or not just stop a university whose image has been damaged from seeking serious remedy from the court. But they don't do that. Thank you.
Thank you very much, my lord. I think we're almost running out of time. But just before we have a lot of other questions here, and we'll try and take all of them within the limited time that we have. Tao, what are your thoughts on international best practice when it comes to remote work? Just within the space of a minute, you could just share your thoughts with us.
Sorry, I'm not sure I got your question.
Hear me?
Yeah, I can hear you. I can hear you, but I'm not sure I got the
Okay.
question correctly.
So,
yes,
yes, my lord has talked about courts. Yes, and the court is for both the employer and the employee. And when you there are a lot of ILO conventions now, and then even protocols on remote work. Some of these conventions we've not ratified, some we have, and the court has a mandate of applying international best practice, which would mean that even for unratified conventions, the court could take those as international best practice. So what are those issues that would come to your mind for parties to put to bear in mind in terms of remote work arrangement when you have to litigate or when you have to ensure compliance with what is currently the norm or the principle that we should apply with?
Okay, thank you very much.
Particularly as it relates to international best practice.
Yes, thank you very much. So I understand you very well now. So for me, when the NIC was elevated to the Court of Superior Record, and then we had the NIC Act to do that, we also then had the amendment to the Constitution by way of Third Alteration Act. We then gave NIC the power, to administer or apply international best practices, which sometimes it can be subjective, if you know what I mean. But the reality is that the court sees that as more like a custom. So if you want the court to help you apply that, you have to specifically plead it and then give evidence on that and prove it. And then the court is at liberty, based on its powers from those two legislation, to apply international best practices. I'll tell you what I have seen. To prove it, it's not that easy. You may have to have comparative analysis of some jurisdictions and put that before the court that this is how it's done in South Africa, this is how it's done in UK, this is how it's done in Brazil, this is how it's done in Russia, and all of that. Mention different maybe countries and all of that. And then you will be speaking to international best practices. Also, the court is allowed to take judicial notice of that, but we know our court is trying to maintain balance. They would tell you to just you prove your case. You have come to court, and then where they need to take judicial notice, the court will take it in addition to the evidence that you have adduced in court. When my lord was speaking earlier on, he said employees court. I was smiling because I had that several times too many years ago. Employees court, employees court. I don't know where the pendulum swings now, but a few years back when we did the analysis, it turned out that the pendulum was slightly on the part of the employer, at that time. But I don't know now because it's an ongoing process, right? So just to allude to the fact that it's a balanced system, both parties can go to court. And I'll tell you a few things. When those things happened, when the legislation came into being, particularly the Third Alteration Act, I thought that was revolutionary. In my view, I thought it was revolutionary, right? And it will change. Instead of going to National Assembly again to change labor law or whatever, that in a way, if you develop very well, case law will revolutionize employment relations in Nigeria. And we've seen it. So there are some positives on international best practices, and I have one negative, right? So positives, for instance, if you look at collective bargaining agreements, before now, typical thing that will happen is that the union can enforce it, but you as an employee may not be able to enforce it except it's incorporated by reference into your agreement. That's when you're able to enforce it. But the new, based on the best practices and new decisions of the NIC, now, even the persons that the CBA, that's collective bargaining agreement, are made for, can enforce it without it being incorporated by reference into their contracts, right? That's one. The second one is on plurality of unionism, right? Before now, you have certain categories of employees, they belong to one union. If you want to go and register for another union, you may be stopped by the provision of the Trade Unions Act of Nigeria. I think, if I remember very well, that would be Section 3, subsection 2, right? So you can't do that. But now, because of international best practices, freedom of association, and all of that, you're able to create more. An employee can belong to more than one union, right? So that's also on international best practices. The one I said keeps going back and forth is the ILO Convention on termination, right? I think in Aloysius' case, my Lord would remember that, right? It was said that, look, you can't be firing at will. You should be able to adduce some reasons why you are laying off a particular employee, sometimes poor performance or for disciplinary action, whatever it is. Just give a reason, right? But what we knew before was, look, for good reasons, bad reasons, or no reasons at all, you can end that contract, right? But then the court, I think that matter went on appeal, and then it was reversed. And where we are today is that employers are still allowed to let go without necessarily giving reasons. And I know what I've seen in practice to ensure that that is doable, right? So what I'm saying in essence is the international best practices as given to the NIC to apply is revolutionary, right? And employers, now, when you are doing this contract, I'll just finish very quickly now. When you are going into contractual relationship and all of that, you should have at the back of your mind international best practices. What is saying in a sound environment, as opposed to sanctity of contract. This is what you have entered into. It must happen. You may have to balance that with international best practices when you are going into that, because the outcome may not be as you have anticipated.
Thank you very much. Thank you very much. We still have lots of questions. Tope has asked about what safety measures is advisable to put in place, either at home or in the office environment. I think we've covered that in the course of the presentation. Rabi and KB has dealt with that extensively. Vishnu is asking, how will we adjust our workplace by using current trends? I think that has partly been dealt with as well. Does anyone want to add to what has been said so far? How do we adjust our workplace by using current trends?
Okay, if I may attempt that, I think that Rabi extensively dealt with that when she talked about bias against so many new developments, right? I think it's for employees and employers to ensure that there's a balance, right? As much as employees want to say, look, it's a new norm, what they call new normal. I'd rather just do it from home. I'm as efficient. In fact, I'm more efficient at home because there are no distractions in the office than coming to the house. The employer knows that sometimes when they have these conference calls and all of that, somebody is on the go, is on the move and all of that. And there should be a meeting for that. Maybe you do a hybrid, you come in for some days, you don't come in for some days and all of that. She talked about, look, also, let's balance, also for employers as well, to be open-minded, have the bench, I think the bench and all of that. You would have a pipeline of those who hold it together, and just accept that what you may have around that may just be revolving players in the true sense of it. I'm not sure whether we can effectively deal with, as an employer, effectively deal with the Japa syndrome that you mentioned earlier on. And the simple reason is this: there's a macroeconomic issue there. Do you understand? And there's probably the one of the corporate, the employer. The macroeconomic issue, you can't be bigger than your economy. Do you understand? So what you can then do is maybe some flexibility around that working out of station, if you find those people integral and integral to your business. So for me, in a nutshell, it's a balance of both ends to ensure that there's a business to be run and also to understand that things have moved, is not where we were, right? For instance, all of us before now would have been in, before COVID. I remember COVID, I was tired of webinars. If you know what I mean. Well, before COVID, we would have to gather in one room, rent one hall, do logistics. There will be, what was that thing called? Refreshment and what have you. I'm not sure you have refreshment for us, Richmond, on this call. So it's more, it's efficient and all of that. We still have the technology issues once in a while and all of that. But people have come to realize that, look, you don't have to physically meet, you don't have to physically assemble to execute work and all of this. So it's just a balance that has to be created and open-minded.
Thank you very much. I think we'll just try and round up within the next 10 minutes. We actually plan not to stay this long. I think there's another question on when people from Asia got an opportunity to work in Europe, Africa, is it difficult for them to follow work policies at the beginning? How would they handle challenges? Any tips? I think this will depend on the circumstance and also the information regarding the particular employee and the place that is going to work. That will determine what tips or answers that can be provided. There is a question on, I think this is to you, Taiwo, on co-employment and outsourcing. You said that for recruitment, you shouldn't have the final say in their hiring, but there are some functions in which you would need to have the final say. If you get a driver from an outsourcing company, the driver that they are assigned to you would have to be verified by the internal staff who would want to use them. In that event, will such driver be seen as your direct employee just because of that?
So the answer is no. So the answer is no, it won't be seen as your direct employee. What you need to do, if you must do, is do a JD, because there's what they call contract of service and contract for service, right? What you are getting into in a triangular employment is contract for service, right? So if you give a job description and the primary employer says that he should give you ordinarily someone that fits that purpose. If not, you just say you don't want. You asking to say, look, let me see and verify or whatever. You are not sitting in the what's it called, the interview room, right? You are not saying, oh no, I like the fair one, I like the tall one. Do you understand? So he just supplies you a driver that knows how to drive and will carry you safely from one destination to another. If you then now say you want to verify the CV of that person, it's a different. Just you making that call. You shouldn't be making the call on who is employed.
Okay, thank you very much. I think this question, either my lord or Ravi may choose to answer. I think in respect of what my lord has stated regarding staff working remotely from home. If a staff chooses to work from home, an employer cannot go and inspect such staff house, as it is the staff that is responsible for his own home and how he works in it. We cannot inspect people's home. That is an invasion of his privacy. So, my lord, I don't know if you would want to have a shot on that. An employer inspecting a staff home who is working from home, will that constitute an invasion of privacy? We may just limit our answer to just within 30 seconds, 1 minute.
That's why I said earlier on that the future will be having a satellite workstation that is a neighborhood workstation that will not be fully the house, or you equip the particular part of the employer's house, like office in the house. If you leave it on demarcated, then there will be this problem that is arising, which the person is right. You can't just invade community respect. So if you want to get the right, they put office in people's homes. One portion of the person's house, a standard architectural design should be included. Oh, this is part of the houses that we need for you. And this type of place should be for office. Even us as judges, we have in all our houses, we have a study, and that study is specific for work. So most of these things you say, is seen involves private employers. Of course, all we have said so far, government,
Right.
public service don't even get involved at all because of the sensitivity of their own doing. So the other private sector, because they are flexible, they can work around different models. Create an office in an employee's home, have a right to inspect it there. Thank you.
Right. Thank you, my lord. I think there's also a follow-up question to that. Ravi may just respond to this. Where you set up workstations and you as employee have to set up a place at their home to work, who bears the cost? I think someone is asking, with this high cost of living and then high cost for employers, who would bear the cost? Would the employer have to engage in all that?
Okay, can you hear me, Richmond? It seems like you're frozen.
I hear you.
I think it's frozen.
Okay, I think he's back on now. So for me, I would say that, yeah, organizations have to be creative with how compensation benefits are managed. I know organizations that have remodeled their benefits package to move some elements into provision for home office, right? So those are things we should look at. Giving stipends to purchase homework equipment, and a lot of organizations are doing that now. So it's important for organizations to consider that in order to make this work from home more palatable for people. So that's my recommendation.
Okay, thank you. And I think a participant is concerned about climate change and the emissions. Having multiple workstations could contribute more to climate change and a lot of other things. Is there a way that we can also put in green housing into place in setting up all of this? Rabi, what's your take?
I saw that comment. I saw some comments, and it's very interesting debate. It's just that we don't have time. So someone talking about the comments made by my lord, and really, he's correct when he says that the future is, I can't remember how he put it, but really there's a concept of hot desking, and working from different locations, which may be the approach, because there's a lot of liability that organizations will incur in the future. And I'm seeing this becoming a very interesting space where employees are suing for so many things because they are working from home and they're not secured and they get injured. So the concept of hot desking, working from satellite locations, is going to be in practice, and at the end of the day may be more cost effective for organizations as against being sued and being dragged to court for so many reasons that it's neither here nor there. But overall, the objective of remote work is to reduce carbon emission, but in the same way, we can partner with organizations who have real estate to ensure that people are in a controlled environment. And that's the whole objective of having these satellite offices.
Thank you very much. I think we still have lots of questions. We may not be able to take all, but just on the issue of confidentiality, I think someone is asking, what if you use your device? How can you curb the dilemma on the trend of using your own device? KB, you want to touch on that? How will you protect the confidential information of the company where the employee has to use a device?
I think I spoke to that earlier, and this is evolving. It started where you only work with company-provided devices, and then there's a bring your own device. But then when you bring it in, the IT, it's what you're also consenting to. You're consenting to the company's IT putting in the necessary protection that needs to be put in on that device. But then there is that limited protection for the company. This is your personal device. Yes, we may put in the protection. So companies are moving now towards, let there be a clear separation. We would provide to you what you need for company work, and your personal device will be your personal device. Because, I mean, it's bad enough trying to retrieve companies' equipment, but your personal device, you would need to bring it in probably when there's a disengagement. There is the obligation, and then it requests cooperation from the employee to bring in that device, as you would do with any device that you're changing out. It is to wipe the data off from that device. So again, IT to the rescue. We really need
Thank you
IT
very
to
much.
make this work. Yeah.
Thank you very much. I think
Which one, please, if I may come in, just
yes.
to clarify, because I can see Aziz asking if I said hot desking. What I said was hot, H-O-T, desking, huh? Not hot desking.
Okay. Thank you very much. Thank you. So I think that's a good, a very safe point to bring this webinar to a close. But before we do that, in 30 seconds, I will just ask for your final thoughts. Starting with, I think, Grabi, you've spoken last, so you can just start from there. So what's your final thought in 30 seconds?
Okay, for me, just 3 words. The first is flexibility. The second is technology. And the third is a values-based approach to managing the whole concept of remote work. So 3 things for me.
Thank you very much. Taiwo, your final thoughts?
Okay, I just probably would like to elaborate on what KB said concerning confidentiality. I think it's straightforward. If you don't want to you don't want access to your private information on office equipment, please don't use it for personal purposes. Separate them. Your private phone is your private, official is official, right? Because it still belongs to the company. Anyway, in some other jurisdiction, they are able to separate. I don't know what that is called in technology, but they're able to kind of ring fence where they see from your phone, just using one single phone, because in most of those countries, they don't use 2 phones, it's just 1 phone, right? But the IT can separate your private from the official site on your phone, and they don't go there. But if you are in this part of the world, my advice would be that use official phones, official laptops for official work, and then
Thank you very much.
private. Yes. Thank you.
Thank you. KB, your final words?
Thank you very much. This is an evolving space. It requires the commitment and a sense of responsibility on both sides to make it work. It's give and take. You are given a responsibility to have this flexibility in the way you work, but you also have a commitment to the company to make it work. And I think clarity of rules, clarity of policies is quite important to make it work. The policies need to be in place, and both parties need to be clear. This is what is required of me. And I think Rabi said something, output, outcome. And I say value over volume. Let's focus on the value. Thank you.
Thank you very much. My Lord, your final words, my Lord?
Rules that work. Rules that work. That is it. So make rules that you can put in place and become effective. If you get an employee, give the employee all necessary equipment, control the equipment, control the staff. So this co-employer, everybody is the employer. There is no more dichotomy between contract for service and contract for service whenever it concerns labor. Otherwise, it's going to be practicing a slave trade. So nobody can hire and give another person and go away as if it's not part of it. So it is a co-employer concept that is now being used. So whether you are working remotely or you are working under outsourcing, everybody is coming together under one concept. So make rules that work for everybody, and everybody will go and work according to what is being set out. So contract is contract for everybody. Thank you.
Thank you very much, my Lord. So the parting words, make rules that work. I would want to also inform everyone, we have our next webinar coming up on the 6th of October, 2023. It's on opportunities and incentives for non-oil exporters in Nigeria from the FMCG sector of the firm. You can also join us on that day for the webinar. It's at 11 a.m. to 1 p.m., 6th of October, 2023. I thank you all for being part of this webinar. At the start, we had almost 150 persons in attendance, and at the moment we still have close to 140. And I want to thank you all the participants for for listening and participating attentively to the discourse we've had today. I thank the speakers, Your Lordship, and thank you very much for honoring the invitation and for your time. I know it wasn't easy for you. I've had a very busy week and over the weekend as well. It has been very busy. Just you had to give us this day today. We thank you very much for honoring us and for being with us today. And KB, thank you. I can't thank you enough for making our time. The notice was short, and yet you came to be part of it. Thank you very much. And Rabbi, you've been with us, and you've been very, very resourceful, and you've been a wonderful person to us. We thank you for your support that you've always provided to us, and we hoping we can continue with the relationship, the business relationship that we have, and taking it forward. So, Taiwo, thank you. You've been part of us, and you've always given us that support and your experience and everything. Thank you for also making this happen and for all the contributions. I also want to thank our IT team, thank our BD team, thank everyone who has contributed to the success, managing partner and the senior partners of the firm. I want to thank everyone. Thank you all for being with us, and we'll see you again. Hopefully, you will join us on the 6th of October for our next webinar. Thank you, and enjoy the rest of the day.
Thank you very much, Ravi.
Bye.
Thank you.
you.
Bye. Thank everyone.
Bye, everyone.
Bye.
Bye, everyone.
Yeah.